Hi, I'm Mark Warner, a judge from the 17th Judicial District, and we're going to talk about expert disclosures under Rule 16 and some other statutes. Criminal Procedure Rule 16, Part 1, D3 governs expert disclosures by the prosecution under the category of discretionary disclosures. Part 2, B1 and 2, generally govern expert disclosures by the defense. The court's discretion guides what discovery in many instances and is subject to constitutional limitations. As many expert witness situations involve psychiatric experts when mental condition defenses are raised, Title 16 may also be implicated. 16.8.5.104 is the statute that waives privileges in competency matters. 16.8.103.6 is the statute that waives privileges in mental condition cases, including insanity. A good deal of published appellate cases deal with issues involving this distinction between materials that are proper for discovery but may also include work product. Rule 16 defines prosecution work product in Part 1, E1. Also, what would appear to be an anomaly for those more familiar with civil litigation, the rules for discovery do not specifically require a party to endorse a witness as an expert. Quoting from People v. Greer, found at 262 Pacific 3rd 920, Criminal Procedure Rule 16.1D3 does not require the prosecution have disclosed experts as endorsed witnesses prior to trial. Instead, the rule places the burden on the defendant to request such information unless the court sua sponte issues such an order. A reason such a sua sponte order may be appropriate includes the fact that police officers are often asked questions that would arguably be expert opinion testimony. There are numerous cases in this genre of police officer testimony that have been either recently decided or are currently being litigated in the appellate courts with differing results. Predominant issues in these cases concern whether the police officer's testimony is actually expert testimony under the guise of lay opinion testimony. As a practice pointer, the court may wish to enter orders regarding expert testimony in the normal course of business in every case. This could avoid a number of potential issues as well as possible continuances. A case worth reviewing in the area of police officer testimony that would be expert is People v. Stewart at 55 Pacific 3rd 107. A useful guide to what the court may require are civil expert disclosure rules, which require the identity of expert witnesses, the qualifications of those witnesses, a summary report of the expert's findings relative to the case at issue, any exhibits used, a list of the expert's publications, the compensation received, and a list of cases which the expert has testified previously. A curriculum vitae, of course, may also be in order. Back to work product. When work product is claimed to be part of the expert materials, the court should conduct an in-camera examination to determine whether portions of the subject materials contain attorney work product. A formal in-camera proceeding may be held under Criminal Procedure Rule 16, Part 3F. A case that also might be useful is the case of People v. Ullery at 984 Pacific 2nd 586. When a party requests an in-camera review for attorney work product interspersed in expert documents, it may be valuable to have that party prepare a privilege log as described in Alcon v. Spicer, found at 113 Pacific 3rd 735, to assist the court in reviewing the relevant portions of the record. Another issue that may arise is the area of raw data for psychiatric professionals. In general, the ethical rules of the specific discipline may prohibit revelation of the raw data used in the expert's evaluation. A court order directing the expert to disclose the data subject to a protective order allowing the other party's expert to view the raw data is a potential resolution.